So good evening and welcome everyone to Auckland University and to Auckland Law School. It's great to see many of you out on a brisk spring evening. To visitors, a special welcome and greetings to you. So my name is Vernon Rive. I'm an academic in the law school and colleague of Professor Foster and Dr. Sobian in the New Zealand Centre for Environmental Law, and it's my pleasure this evening to chair this evening's session. I'll say a little bit more about the speakers in a minute, but for now, let me welcome and point out to you Professor Caroline Foster, Jessica Pellaretz, Robert Kirkness, and Justin Sobion. We'll hear a little bit more from them in a minute. Now, many of you, because you're here, will be familiar with the International Court of Justice's advisory opinion on the obligations of states in respect of climate change. But I'm going to provide a very brief scene-setting overview, and then I will introduce the four speakers. The advisory opinion was delivered with suitable pomp and ceremony by the International Court of Justice on the 23rd of July of this year. In a piece for the European Journal of International Law, Melbourne law professor Margaret Young describes how there were gasps in the courtroom when the ICJ President Yuji Iwasawa read out the court's unanimous opinion. And it's been variously described as landmark, historic, far-reaching, the most significant development in international climate change law since the adoption of the Paris Agreement. And our speakers are going to guide us through some of the key elements and findings of the opinion, which will help us assess, I guess, whether these descriptions are accurate. Now, this is the second event that the law school has put on the ICJ opinion this year. In May, we hosted a panel discussion featuring two of the advocates for small island states who appeared before the ICJ, one of whom was Justin. In that session, we covered the remarkable backstory to the ICJ climate change advisory proceedings. I'm not going to revisit that now, but I did want to briefly highlight the two questions that were approved in April 2023 by the UN General Assembly in their referral of the questions for the International Court of Justice. So UNGA Resolution 77276, it starts with a preamble, as many of these do, listing a variety of sources of international law seen as relevant to the court's task. And of course, the core climate treaties are on the list: the United Nations Framework Convention on Climate Change and the Paris Agreement, the Kyoto Protocol. But so are instruments outside of the UN climate regime: the UN Charter, the International Human Rights Covenants, the Convention on the Law of the Sea. But that list of sources also includes customary international law obligations, including what's colloquially known as the no harm principle and the duty to protect and preserve the marine environment. Also featured, and Caroline, I imagine, will come to this, is the duty of due diligence. So we can see from this preamble that the UNGA was looking to the court to analyse, to synthesise, to clarify and affirm the sources, the characters and the content of international legal obligations, with that list as a starting point but not an end point. Then we come to the two questions. The first asks, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? So that's the first question. The second asks, what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment? And it asks the court to approach that question having in mind at the forefront, first, states, including small island states, and second, peoples and individuals of the present and future generations affected by the adverse effects of climate change. So when Caroline and others talk about the first and second questions, let's just keep that in mind. First question, what are the state's obligations to protect the climate system and the environment from climate harm? Second question, what are the legal consequences for states where by their acts and omissions they have caused significant climate harm? So over 130 pages, the advisory opinion covers significant ground, which will keep lawyers, judges, academics, students busy for years. But you can skip to the last 3 pages, the dispositif, for the key conclusions. And there, the court found unanimously that it had jurisdiction and it would issue an advisory opinion responding to those questions, and it made a series of core findings. Some of them perhaps not so surprising, affirming the legal obligations on states under the UN climate treaties. Other obligations, perhaps not exactly surprising, but still welcomed because they clarified important aspects of the international legal framework which is relevant in this context, including the affirmation of obligations under customary international law relating, amongst other things, to that no harm principle which I mentioned, and also the really important duty of states to cooperate with each other when taking decisions and implementing measures in relation to climate change. So the court, in response to the two questions, at first affirmed that there were indeed legal obligations on states in relation to climate change. Second, although a smaller part of the opinion, it addressed the consequences of states breaching the obligations which the court has set out, including significantly and a little controversially the potential remedies of reparation to injured states in the form of restitution, compensation, and satisfaction. All right, that's a bit of a background to it. And as I said, the real experts on this are going to lead us through some of the significant parts of this. So we've got four speakers tonight. Caroline Foster, a leading international environmental and climate law expert. She served as legal counsel for the International Union for the Conservation of Nature, and she will be up first. Caroline will be followed by Jessica Pallieret, who's the Executive Director of Lawyers for Climate Action, and we're really pleased to have some other members of Lawyers for Climate Action board here tonight. After Jessica, we'll hear from Robert Kirkness, a leading barrister at Thorndon Chambers in Wellington, with a broad commercial, public and international law practice, including extensive experience in human rights law. And then finally, Dr. Justin Sobian, who has recently completed his PhD on Earth trusteeship through Auckland University. He was counsel for Grenada, St. Vincent and the Grenadines. After they've spoken, there'll be a chance for you to make some comments, to ask some questions of the panelists. So we really encourage you to listen hard, get your questions ready, and I will return at the end. Thank you, Caroline. I'm going to hand it over to you now.